The Honourable the President.
Let us pray. Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President.
Honorable Senators, I have granted leave of absence to Senator Alison Bash and Senator Dr. Daneshwar Mahabir, both of whom are out of the country, and to Senator H.R. Ian Roach, who is ill. Honorable Senators, I have received the following correspondence from His Excellency the President Anthony Thomas Aquinas Carmona, ORTTSC. The Constitution of the Republic of Trinidad and Tobago, by His Excellency Anthony Thomas Aquinas Carmona, ORTTSC, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. Nikolai Edwards. Whereas Senator Daneshwar Mahabir is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Nikolai Edwards, to be temporarily a member of the Senate with effect from the 22nd of June 2017 and continuing during the absence from Trinidad and Tobago of the said Senator Daneshwar Mahabir, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 22nd day of June 2017. To Mr. Albert William Benedict Sidney, whereas Senator Hugh Russell Ian Roach is incapable of performing his duties as a senator by reason of his illness. Now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Albert William Benedict Sidney, to be temporarily a member of the Senate with effect from the 22nd of June 2017 and continuing during the absence of Senator Hugh Russell Ian Roach by reason of his illness, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 22nd day of June 2017. To Ms. Alicia Romano, whereas Senator Alison Bash is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago. Now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Alicia Romano, to be temporarily a member of the Senate with effect from the 22nd of June 2017 and continuing during the absence from Trinidad and Tobago of the said Senator Bash, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 22nd day of June 2017. Honorable Senators are required to take the oath.
I, Alicia Romano, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Nikolai Edwards, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Albert William Benedict Sidney, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Questions.
Senator Richards.
Thank you, Madam President. Good afternoon, everyone. To the Minister of Rural Development and Local Government, in light of complaints from residents of Arapoon Gardens, St. Helena, Penal, Faizabad, and Barrackpore on the lack of relief in the aftermath of the passage of Tropical Storm Brett, can the Minister give reasons for this delay on the part of the relevant corporations?
Madam President, the Minister of Rural Development will be here shortly. Oh, he just came in? Okay.
Minister of Rural and Local Government.
Thank you very much, Madam President, and thanks, Senator Richards, for the question. It's a long answer because it's a storm and it has a lot. Has a lot to do. I have 2 minutes, I have 5 pages, so Madam President, I'll try to be brief. Okay. First, I want to say, special commendations must be given to all the corporations, the 14 corporations throughout Trinidad, the aldermen, the councillors, the administrative staff, and also to the volunteers that took part and shared in this storm. The delay, reasons for the delay, the respective disaster management units in all 14 corporations have been preparing their staff not just recently, but over a period of time. And I want to commend them as an integral part of as being the first responder, along with Tiantec, WASA, Fire Service, Police, Defense Force, and the disaster unit in each corporation. Disaster coordinators from Tunapuna, Piako, and Arima man the East EOC at the ODPM in Tagarigua.
The time is up. Senator Richards.
President. Minister, I know your answer was incomplete, unfortunately. I hope you can answer possibly the rest of it in the next question because they are related. Is the Ministry aware of a matrix for assessment and prioritization of relief efforts, given the fact that there are 14 corporations and the damage and the impact has been so widespread, that can be communicated to residents and purchasers so that they know they may not be priority in terms of the severity of their affliction, but the authorities are coming to them?
Minister.
Thank you very much, Madam President. Madam President, I was out in the field, so I understand the pain of the people and so on. And in the 14 corporations, the councillors have been assessing, the chairmen have been assessing the residents that have been affected, the citizens that have been affected. And they have our owners. Now, recently, I don't know if you heard that the government just approved $25 million for another question. Yeah. Huh? Yeah, emergency funding. So we're going to take that into consideration and send it. The requests that come from the mayors and chairmen and the councillors and aldermen, and prioritize what they need, whether it's fridges, stoves, foodstuff, clothing, house grant, because a lot of people are affected. Roofs were blown off and so on. Farmers were affected. All these people were affected. So I think I had a one-on-one with each corporation. I've been constantly before the storm, after the storm, and I will continue to have it, and I hope that will bring some relief to you, Senator.
Thank you, Madam President. Minister, how much emphasis is also being placed in collaboration with the Ministry of Health, given that now the other aspect of this is sewer systems have been flooded out and there are health concerns in terms of that, in addition to possibly mosquitoes breeding and the impact of those sorts of afflictions?
Madam President, very good question, and we observed that while visiting the citizens. Once the water subsides, there's where the assessment will come in. And the public health department in each corporation has the owners to check. Spraying has to be done. Not only public health inspectors, the building inspectors, I spoke to a couple of them this morning, and they have to go around to make sure and inform the citizens what we intend to do, each local government body, what we intend to do for them.
Next question, Senator Richards. No, there are only 2 supplementary questions. Next question, Senator Richards.
Thank you, Madam. To the Minister of Works and Transport. Given that the Ministry of Works and Transport is responsible for dredging of watercourses, what immediate action is being taken to address the drainage problems highlighted by the passage of Tropical Storm Brett?
Minister of Works and Transport.
Thank you, Madam President. Madam President, the Ministry of Works and Transport, through its Drainage Division, has an ongoing program of cleaning and desilting watercourses throughout Trinidad. Measures undertaken to deal with the effects of the Tropical Storm Brent are: river control gangs are presently deployed across the country, cleaning debris in block watercourses. Cleaning of major blockage on the Tacarigua River, the Fremont Road, with heavy equipment is currently in progress. The silting of the Cipero River from cross-crossing to Gulf City Link Road is in progress. We are waiting water levels to drop in the Oropuch Lagoon to assess the work to be done. Awaiting water levels to drop in the Caroni Basin to assess work to be done. Awaiting water levels to drop in the North Oropuch River Basin to assess the work to be done, and awaiting the water levels to recede at the Caparo Water Basin to address the work to be done. Thank you, Madam President.
Senator Richards.
Thank you, Madam President. Minister, could you indicate to this Honourable House, if there has been an identification beforehand or now of the waterways or the watercourses that are most vulnerable to this type of affliction with the passage of tropical storms or even heavy rains.
Minister of Works and Transport.
Thank you, Madam President. Madam President, the answer for that is yes. And that assessment is what influenced the river cleaning and the dredging that have been going on for the past 2 months. Thank you.
Senator Richards.
Yes. I'll give way.
Senator Amin.
Thank you, Madam President. To go along with the dredging of the rivers, could the minister indicate if the ministry has done an assessment of the irrigation systems that we have reports that some of these systems fail, the sluice gate and pump systems that cause flooding, if you have done an assessment of those that were compromised?
Minister of Works and Transport.
Thank you. Madam President, as far as I'm aware, the sluice gate system actually protects water from coming into the land once the tide is high in the ocean. So unless the water recedes, I can't confirm that what the senator is saying, that the sluice gates fail. It might be deliberate not to open them to have the salt water flooding the freshwater areas. But we are in the process, and again, everything has to happen once the water is receded. Thank you.
Senator Mark, next question.
Thank you, Madam President. To the Honourable Prime Minister, can the Prime Minister state whether an emergency fund will be established for the purpose of assisting in disaster relief post-tropical storm Brett?
Minister in the Office of the Prime Minister.
Thank you very much, Madam President. Madam President, as my colleague a short while ago alluded to, this morning at Cabinet, the Honourable Prime Minister came to Cabinet and asked us, he put forward a proposal and it was accepted by Cabinet. The Minister of Finance is going to make available a fund of $25 million for distribution through existing means to assist all of those who have been affected by the adverse effects of Tropical Storm Brett. That would be the Ministry of Works and Transport, the Ministry of Social Development, the Ministry of Local Government and Rural Development, as well as the Ministry of Agriculture. And through the utilization of the existing processes and procedures in these various ministries, grants and other funds would be made available to those who are deserving.
Senator Mark.
Madam President, could the Honourable Minister indicate to us, given the severity and the gravity of the dislocation caused by this tropical storm, whether the government would be considering increasing the quantum of funds allocated to the emergency fund, maybe up to 100 million as an example?
Madam President, the government has allocated as a cabinet and taken a decision at the amount of $25 million. It appears as though the opposition is not aware of what is going on with the country financially right now, and we would authorize any sums of money that are needed and necessary. At this stage, that allocation is $25 million. My friends on the other side had a propensity to work in hundreds of millions.
Honourable Senators, the time for urgent questions has expired.
We'll extend the time because of the situation with Brett.
Sure. Senator Mark.
Thank you very much, Madam President. Thank my colleague as well. May I also ask the Honourable Minister whether it is the intention of the government to review this sum having regard to unfolding circumstances and events, whether the government is prepared to review that quantum?
Minister in the Office.
Madam President, as I alluded to in response to the last supplemental question, this government is always reviewing its position. At this stage, the allocation is $25 million.
Next question, Senator Mark.
Thank you, Madam President. To the Honourable Minister of Agriculture, Land and Fisheries, given the losses experienced by farmers as a result of Tropical Storm Brett, can the Minister state what measures are being implemented to assist said farmers?
Minister of Agriculture, Land and Fisheries.
Madam President, I thank Senator Mark for his question. Madam President, the ministry took note of the possibility of bad weather since last week, Wednesday. In fact, last week, Thursday, the Minister of Works and Transport and I went on the East Coast, recognizing the vulnerability to bad weather of that coast. We also did further preemptive measures through the issue of bulletins and warnings to stakeholders, in particular fisherfolk, given the historic damage to vessels when we have bad weather. Since the passing of Brett, Madam President, the ministry has done three things in particular. The first is in accordance with the well-established policy within ADB. We've asked the Agriculture Development Bank to work with farmers who are likely affected by the floods in order to deal with their monthly payments that they would make. The second is that we've asked all divisions of the ministry to support the recovery efforts, whether or not they are linked to farmers, whatever is required in the communities. In fact, yesterday, officers of the ministry staff were out in the fields assisting people in schools and in communities. And the third thing is, in the normal way, we deal with claims for assistance following a flood. We've already received a few hundred applications. We have a well-established process. Farmers understand what they have to do, and the ministry, of course, is committed to deal with all bona fide claims for assistance in this. I could say, Madam President, there is no doubt, based on the fact that I've been across the country having a first-hand look at it, there has been damage to some of our better farmers across the country in places like Tabaquite, Orange Grove, and in Deep South, Penal and Woodland and those areas. Thank you.
Senator Mark.
Madam President, can I ask the Honourable Minister, what are the likely consequences arising to business and consumers given the extent of the dislocation to crops and livestock in the Republic of TNT?
Minister of Agriculture.
Madam President, it's difficult to give an exact figure, but I can say based on what I've seen, in some categories, for example, when you look at the Tabaquite area, which is a major supplier of crops like cabbage and tomatoes, there's been significant damage. Some of the fields are in the final cycle of production, and those fields would have been replanted. So what we would have is we'd have crops which should have been ready for the market by this weekend are now being unavailable. And then we may have some delays in the replanting effort as the farmers clean up the fields and so on. In relation to livestock, I know about one loss in Debe, which is essentially contract farmers, so that by the weekend we'd be able to, NAMDEFCO is out in the field today trying to gauge the impact. But based on what I've seen, I could say with some certainty we'll have some issues on the supply side. The extent to which it will affect prices is something we would still see. And in relation to livestock, I'm not in a position to gauge the impact. Of course, the private processors control a significant part of the market, and they would try to manage and recoup.
Senator Mark.
May I ask the Honourable Minister, from his own assessment, what is the extent of the damage to access roads as it relates to the farming community?
Minister.
Well, I'm happy to say so far, with the exception of the Tableland area where the ministry is currently engaged in developing access road, and Tableland is particularly vulnerable to bad weather, I have seen no damage to access roads as I've been across the country.
Next question, Senator Mark.
Thank you, Madam President. To the Honourable Minister of Education, can the Minister provide specific dates for the resumption of classes in schools that have been closed as a result of Brett?
Minister of Education.
Thank you very much, Madam President. The following schools were closed because of the effects of Tropical Storm Brett. However, most of these schools have reopened today. They are Todd's Road RC, St. Helena Hindu, North Opuch Government, Fishing Pond Presbyterian, San Rafael RC, Mundo Nuevo RC, Faizabad Anglican, Faizabad Secondary, DB Hindu, and Canai Road Presbyterian. There are 5 schools that are still closed. They are the North Oropouche RC, Mayo RC, Rosalak Hindu, Warrenville TIA, and Warrenville Presbyterian. These schools that have been closed, the main reason is the access roads to the school. Those roads have been closed off because of rising floodwaters. Thank you very much.
Senator Ma.
Madam President, could the Honourable Minister indicate whether any schools, primary and or secondary, remain closed as a result of those facilities being used as shelters as a result of the tropical storm Brett?
Minister of Education.
Thank you very much, Madam President. There are 3 schools that were used as shelters. My information is one of those schools have been returned to the school population, and that is Valencia Government School. The other 2 schools, I can't remember the name right now, but there are 2 other schools that the names of those schools just evade me. If I remember, I'll let him know. I'll provide him with that information.
Senator Ma.
Could the Honourable Minister indicate when would he expect those schools that have been made impassable because of the rising flood waters? Do you have an estimated time as to when those schools should be ready for occupation by students?
Minister of Education.
Madam President, we have no control over nature, and therefore it is impossible for me to state when those schools will be able to resume operations. Only today, 2 schools were closed, the Warrenville TIA and the Warrenville Presbyterian, which were not closed previously because today the banks of the Caney River overflowed, preventing these schools from being open. And therefore, I am unable to answer that question.
Next question, Senator Mark.
Madam President, to the Honourable Minister of Public Utilities, based on TNTEC's statement that there are currently some 25 areas without electrical power as a result of tropical storm Brett, can the Minister inform the Senate of the time frame within which a supply of electricity will be returned to the affected communities?
Business.
Thank you very much, Madam President. Madam President, there were around the country some 375 disruptive events as a result of Brett. The large majority have already been restored. There are, however, 6 areas in the north, 7 areas in the south, and 9 areas in the east yet to be restored. These are expected to be restored by 11 p.m. tonight.
Question for notice, question for oral answer.
Madam President, through you, we'll be answering questions numbers 96, 97, and 100, and we ask for a deferral of 2 weeks for question number 95.
Question number 95 is deferred for 2 weeks. Senator Mark.
Thank you, Madam President. Question number 96 to the Honourable Minister of Education.
Minister of Education.
Madam President, the first point I wish to make is the sum that is referred to is not $2 million, it is $510,000. Madam President, the Education Facilities Company Limited is the special purpose company charged with the responsibility to provide project management services for the government's school construction program, which includes construction, repair, upgrade, and outfitting of public schools. Contracts are therefore awarded by the EFCL for the conduct of these activities on behalf of the Ministry of Education. Invoices submitted by contractors undergo a verification process by the EFCL and the Ministry of Education, after which, once funds are available, the ministry issues a check to EFCL for the contract sum plus its project management fee of 7.5%. The EFCL then pays the sum owing to the contractor. Thank you.
Senator Mark?
Madam President, could the Honourable Minister indicate that whether he's aware that the EFCL owes contractors approximately $800 million, and therefore could the Honourable Minister indicate whether this activity could be seen by the public as favoring one contractor over hundreds of others who are currently owed by the EFCL?
Senator Mark, you asked two questions there. You asked whether, you asked two questions. I will allow the second question. Minister?
Madam Chairman, Madam President, the simple answer to the second question is no, the Ministry of Education nor EFCL does not favor any contractor. In this particular case, the payment was made to a contractor who was engaged in the Mova Laventel project, which is a special project, and therefore we had contractors from the area effecting works in those schools. Thank you very much.
Senator Mark?
Madam President, could the Honourable Minister indicate to us how many contractors are involved in this project that you have mentioned in the Mova Laventel community? How many contractors are involved?
Senator Mark, that question doesn't arise.
Could I ask the Honourable Minister, therefore, whether it is a normal practice for his advisor to provide a check to a contractor whenever work has been completed? Is that a normal practice for the minister's advisor to provide a check to a contractor for work commissioned or completed? Is that a normal practice?
Minister of Education.
Madam President, Senator Mark reminded me of a school teacher repeating a question 2 and 3 and 4 times. Madam Speaker, I crave your protection. It is not the practice, and my advisor never provided any contractor with any check.
Madam President, the contractor, Sunboom Contractors, could the Honourable Minister indicate to us whether this was the only check issued to this contractor under your stewardship? Could you advise this Honourable Senate whether this contractor, Sunboom Contractors, is the only contractor by name who has received a check under your stewardship during your term of office?
Minister of Education.
Madam Chairman, again, Senator Mark has asked 2 different questions. His first question was whether Sunboom received only 1 check. And then he went on to say whether there are other contractors who receive 1 check. I would like clarification first before I can answer.
Well, there can be no, you've asked...
Well, could you answer the question? Because to which one?
Which question to answer?
Well, I want clarification on the both.
Well, asking for clarification of both means you've gone over. You're allowed 4 supplementary questions. None. Yeah.
Well,
so,
could I ask you? I want to get clarification.
Yeah. All right, I will allow it for you to clarify very briefly if the minister can respond.
Yeah, Madam President, could the Honourable Minister indicate to this House whether Sunboom Contractors receive only 1 check under your stewardship thus far?
Senator Mark, that question doesn't arise. No. So let's go to the next question. Senator Richards.
Thank you, Madam President. Question number 97 to the Minister of Health.
Thank you.
Minister of Health.
Thank you, Madam President, and good afternoon to all. And I thank Senator Richards for the question, because this has engaged my attention as Minister of Health and the Cabinet of Trinidad and Tobago. Because as part of its NCD program, I should tell the population, the question is, are we going to ban the importation of energy drinks? The government of Trinidad and Tobago has already taken a policy decision to ban the availability of energy drinks in all primary and secondary schools as part of its NCD program. At this time, there are no plans to ban its importation, but the focus will continue to be with a public education program into healthy lifestyles and to have the population avoid all products that put the population's health at risk. Example, the excessive intake of sugar, refined flour, smoking, alcohol, high fat and high calorie foods. We, the government, the ministry, is confident that a well-educated public, as we are seeing already with the NCD program, can then make better life choices, including the use of energy drinks. Thank you, Madam President.
Senator Richards.
That's, and with your articulation that the government has no plans to ban, given what we've seen in other jurisdictions, inclusive of some US states, Uruguay, Germany, where there have been deaths attributed to some of the energy drink usage. Does the government have plans to regulate the caffeine level in some of the drinks? Because that's the next possible step.
Thank you.
Minister of Health.
Yes, thank you very much. That's a very interesting question. And Canada has actually capped its caffeine level in energy drinks to 180 milligrams per serving. But to alert the population and Senator Richards how difficult this is, do you know that a brand of coffee served in Trinidad and Tobago, the grande size, 16 ounce, has 330 milligrams of caffeine, much more than the caffeine levels in energy drinks. So we have to be careful in these things. Very often, caffeine is a problem, but very often the caffeine levels in energy drinks are actually lower than the caffeine levels in large servings of coffee. So on what basis are we going to ban energy drinks if you're looking at caffeine? What I think we need, Senator Richards, what we have done, the most vulnerable groups for energy drinks are teenagers and young adults. That's what all the research shows. The countries that you mentioned that have banned these energy drinks didn't ban it for caffeine. They banned it for high levels of taurine, which is a stimulant that kickstarts your metabolism. It wasn't banned for caffeine. So we have to be careful how we interpret the data coming from abroad. But your concern is shared with us. And we have to change the hearts and minds of our young people into using these drinks and not to abuse them. And we feel confident as part of the NCD program, which we have launched and which is gaining traction, that people are actually avoiding all these foods and drinks that are not good for them. And I'll tell you something, the backlash has already started because we are impacting on the sales of many of these products which are not good for the population's health. So I share your concern, but an outright ban is not on the cards right now. We will continue, and I hope you support us in this, with a very vigorous education drive on the use of all products, tobacco, alcohol, sugar, refined flour, and energy drinks. I thank you, Madam President.
Senator Richards.
Madam President, with that said, is the ministry also looking at, and you indicated that the issue is the taurine and not the caffeine, but in the jurisdictions that have regulated and or banned the energy drinks, the concern is not only the caffeine, but the regular mixing of the caffeine with alcohol, and sometimes in packaging that is what ends up dangerous.
That's an excellent question, because I myself at Carnival time warned the population not to use energy drinks as a chaser for alcohol. So yes, the cocktail of alcohol and energy drinks is bad. But then if we want to ban it because it is used as a chaser, then how far down the road do we go? Because do we ban club soda? Do we ban coconut water? The banning of a product entails a lot of research, a lot of thought, and a lot of evidence. The evidence so far tells us that the vulnerable age group are those teenagers and early and young adults, 15, 25. And as I said, banning it in schools already is impacting on the minds of our young people that they need to change their habits. The countries not many countries have actually banned the importation of these drinks. Kuwait has banned its sale to under 16s. Latvia has banned it to minors. And as I said, Germany, you mentioned Germany in 2009, didn't ban it for caffeine. They banned it because one product had traces of cocaine in it. So those are the reasons why it was banned. So we have to be very careful because we live in a free society. We have to decide what type of society we want. And we feel in an open society like this with free trade, the best approach, and it has been backed up in research by the West Indian Journal of Medicine and WHO on whose writings I am guided, that the best approach now is public education to our young adults into the judicious use of these drinks. I thank you, Madam President.
Madam President, can I ask my honourable colleague, what mechanisms are being established to enforce the ministry's decision in an effort to avoid consumption of these energy drinks and consequently the creation of a black market in the very school system that utilize, or you are banning the utilization of those energy drinks?
Minister of Health.
Thank you. Thank you, Madam Speaker. Madam Speaker, we are hoping and we are confident that as we educate the public more and more, that children and families and parents, and the evidence is starting to come into us, are now making better life choices. We can't ban everything, otherwise we'll be banning every chicken and chips outlet. We'll be banning every roti shop. Because I'll tell you something, the effect of sugar and flour is much more dangerous to this society than energy drinks. So we have to be careful what we ban. What we feel at this time is a serious public education program. Smoking and alcohol, there's much more evidence that those products contribute directly to death. Do we ban them? What type of society do we want? And we feel society will make better choices of these products which are not good for them, but let us educate them and decrease their usage, whether it's excessive sugar, whether it's excessive refined flour, smoking, alcohol, and energy drinks.
Next question, Senator Richards.
Thank you, Madam President. Question number 100 to the Minister of Education.
Minister of Education.
Thank you very much, Madam Speaker. Madam President. Thank you very much, Madam President. Madam President, the Ministry of Education has a number of measures in place to mitigate minors engaging in sex acts while at school. These include: 1, reinforcement of the school code of conduct, highlighting the consequences of such action to students. 2, strengthening the system of supervision of students. 3, universal intervention and information sessions from primary to secondary level, coordinated by the Student Support Services Division in several critical areas such as respect for self and others, understanding the Sexual Offences Act and the legal implications, decision making, in which negating skills are reinforced and different ways to say no, child rights and protection, self-development and the self-esteem enhancement and values education. And 4, a health and family life education program which addresses sexuality and the sexual health starting from infant 1, where concepts such as good touch, appropriate touch are introduced With respect to B, students who are found guilty are suspended in conjunction with the appropriate psycho-social counseling and intervention by Student Support Services Division of the Ministry of Education. For severe cases, social workers, behavioral specialists, and clinical psychologists are required. And the third question, schools are guided by the National School Code of Conduct, which promotes responsible and ethical use of social media and requires that all interactions on the social media be respectful, age-appropriate, non-abusive, and free from ignominious content. The school discipline matrix, which is guided by the National School Code of Conduct, determines consequences for breaches of the code. Consequences for such acts of indiscipline range from student and the parent conferencing to extended suspension and referral to the learning enhancement centers. Thank you.
Senator Richard.
Thank you, Madam President. Can the Minister indicate if the outlined Student Support Services presently has a manager on board?
Minister of Education.
Present, there's no manager, but there's someone who's holding on and discharging the responsibilities of leadership of that department.
Senator Richard.
Can the Minister indicate if the Ministry of Education has a student cell phone use policy in place, given the fact that it seems that unfortunately we're seeing more and more of these videos and photographs of students unfortunately engaged in sex acts coming through the use of cell phones?
Minister of Education.
Madam President, yes, the Ministry of Education has a cell phone policy, and the policy states that while a cell phone is allowed in schools, those cell phones should not be camera cell phones. However, one can hardly find now a cell phone without the camera facilities, and that is one of the challenges that we face.
Thank you, Madam President. With that said, and because of the obvious concerns one would have with that, yes, most cell phones come with a camera. Has the ministry plans to update this policy to deal with this evolving situation because of the threat it poses to students?
Thank you very much, Madam President. At present, the Ministry of Education is having discussions with various arms of the Ministry of Education, in particular the Student Support Services Division, in an effort to update its policy. Thank you.
Senator Amin.
Madam President, arising out of an answer earlier from the Minister, is it that the Ministry of Education is considering having sex ed in schools?
Senator Amin, that question doesn't arise.
Well, Madam President, if I may clarify.
Well, you've asked one question already.
No, it's not on your question. Earlier, the Minister indicated that they plan to do programs sharing with children good touch and bad touch and so on in schools. So that is an element of sex ed. So I'm asking if the ministry has any plans to introduce sex ed in schools.
Minister of Education.
Madam President, the question that is posed by the good senator, I am confused because she dropped the last word, so I am not sure whether she's asking whether the Ministry of Education is going to encourage sex in schools or whether it's going to encourage sex education.
Sex ed.
Oh.
Sex ed. Sex ed, it is the shortened version of sexual education. Does the ministry plan to have sex education in schools?
Same time, and no need for us to be, let's just, Minister, have you gotten the supplementary question now that has been posed? Yes. Minister.
Thank you very much, Madam President. Again, the Ministry of Education is engaging the assistance not only of our various departments, but of our parents and of the church. We have a program that is referred to as Parenting and Education, in which we seek the support and the involvement of parents. Also, since this is a very touchy subject, especially where certain religions are concerned, we are engaging the religious bodies in discussions. We have not yet come out with a definite policy, but it is on the basis of discussions that we are having at present.
Can I ask the Honourable Minister, having regard to the various measures outlined earlier in your presentation, could you indicate to us whether you have discerned any tangible reduction in the activities of students as outlined in the question? In other words, given your measures, have there been a reduction or tangible reduction in sexual acts committed by students?
Minister of Education.
Madam President, to answer that question, I can only base it on the request for extended suspensions that come before me. As all of us know, it is only the minister who has the authority to extend the suspension. What I have found over the last few weeks and months is that there is a drastic reduction in the number of requests for extended suspensions, which sometimes include students having sex in the classrooms.
Request for leave to move the adjournment of the Senate on definite matters of urgent public importance, statements by ministers or parliamentary secretaries, personal explanations, introduction of bills, motions relating to the business or sitting of the Senate and moved by a minister, public business, government business, committee business, motions.
Minister of Agriculture, Land and Fisheries.
Madam President, I beg to move the following motion standing in my name. Be it resolved that the Senate adopts the report of the Special Select Committee appointed to consider and report on a bill entitled An Act to Amend the Offences Against a Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters. Madam President, you would recall that on Tuesday, June 13, 2017, a Special Select Committee was appointed to consider and report on a bill entitled An Act to Amend the Offences Against the Persons Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters. Madam President, you would also recall that the Senate agreed to the appointment of the following persons to serve on the Select Committee: Clarence Rambharat, Michael Coppin, Senator Michael Coppin, Senator Daniel Duki, Senator Gerald Ramdeen, and Senator Sophia Chote, Senior Counsel. Madam President, this Select Committee met on 2 occasions, and on both occasions we had full participation from the members who were appointed to the committee. Madam President, on the first meeting, the committee agreed in accordance with the General Rules Appendix 3, number 9 of the Senate Standing Orders, to a request by Senator Jennifer Raffoul to participate in the meetings of the committee without the power to vote. Madam President, you'd also know that in accordance with General Rules Appendix 3, number 10 of the Senate Standing Orders, the mover of the bill, the person in whose names the bill stands, is able to participate in the proceedings without the right to vote. In accordance with that rule, the Honorable Attorney General and Minister of Legal Affairs, Faris Al-Rawi, participated in both meetings of the Select Committee. Madam President, by way of reference, the committee was mandated to consider the details of the bill and also report to this House by Tuesday, June 20th, 2017. And you may recall, Madam President, that on Tuesday, June 20th, 2017, I duly laid the report of the committee in this House. Madam President, the core work of the committee was to conduct a clause-by-clause analysis of the bill and to make the appropriate recommendations to the House. Madam President, I must say that in the clause-by-clause analysis, the committee was very grateful to have, in order to provide assistance and guidance, Professor Gerald Hutchinson, a forensic psychiatrist. The committee having determined that some of the matters contained in the bill require that level of professional guidance. Madam President, I believe, and I'm sure the other members of the colleague will agree with me, that having Professor Gerald Hutchinson to assist us allowed us to reach consensus in the matters contained in the bill. I must also say, Madam President, before I go into the clause-by-clause analysis, I must also say that we are very grateful to have the support of the CPC and his staff during that period, and they were enormously helpful to all of us. Madam President, the committee examined the bill, and in particular, the following clauses in the bill. The committee examined Clause 3A2, which deals with the aggravating factors which must be taken into consideration upon the fixing of a period of detention to someone who has been determined to be suffering from an abnormality of the mind. And in those aggravating factors, the committee considered in particular two areas, one relating to the factor of evidence of a plan and premeditation, and agreed to the amendment of that section of the bill. The committee also considered as an aggravating section an amendment to Clause 3A, Section 4A, subsection 9G, and agreed to an amendment of that part of the bill so that it now reads, the killing of any person doing his public duty, including a judicial officer, member of the Defense Force or Protective Services, customs officer, immigration officer, or postal worker. Madam President, the committee also looked at Clause 3A2, Section A, subsection 10B, in relation to the consideration of a definition of the issue of subnormality or mental abnormality, and agreed to the adoption of a definition from the Mental Health Act as amended to delete references to age. The committee looked at Clause A2, Section 4A, subsection 13B, in relation to the reports which have to be submitted on an annual basis on someone who has been determined to be suffering from an abnormality of the mind. The committee agreed to an amendment to include a reference to an up-to-date mental assessment report from a psychiatrist, including an independent psychiatrist. And that amendment, Madam President, was meant to replace the reference in the bill to a medical doctor. The committee also agreed to include a new subsection, Clause A2, subsection 4A, subsection 14, and that is to provide, on the basis of advice and guidance received from Professor Hutchinson, to provide that after 3 years, there shall be an independent review of the mental assessment report, and the independent reviewer should have access to the person's history. And that is based, Madam President, on advice we received from Professor Hutchinson in relation to, in some cases, the difficulties in having access to professional advice relevant to the particular case. And the committee felt that during every 3 years, there should be an independent review, and that reviewer should have access to the previous records of the person being assessed. In Clause 4D, Section 42B1, the committee addressed its mind, Madam President, to the time frames within which a decision maker has to deliver a judgment and also the reasons, and agreed to recommend that Clause 4D be amended to replace the word currently existing judgment with the word verdict, and replace the wording for the conviction of the accused person with for his verdict. Similarly, the committee looked at Clause 4D, Section 42B, subsection 4, and agreed to recommend the replacement of the words "the acquittal" with the words "his verdict." Again, committee's aim was to ensure that we have consistency of language, recognizing in the original framing of the bill the words "written judgment," "judgment," and "acquittal" were used interchangeably, and the committee settled upon the standard language of verdict. Madam President, the committee looked at Clause 4D, Section 42B, subsection 4, and again agreed to the replacement of the word "the acquittal" with "his verdict." In relation to Clause 4D, Section 42B, subsection 6, the committee agreed to replace the word "judgment" with the word "verdict." And finally, Madam President, committee looked at Clause 4D, Section 42B, subsection 7, and agreed to the deletion of that section. Madam President, I believe that notwithstanding the short time frame, the committee conducted itself in a very professional and expeditious manner. We resisted the effort to delay based on the holidays that intervened, and the committee is very happy to produce this report and recommend it for adoption by the Senate. I thank you.
Minister. Yes.
Madam President, I beg to move.
Honourable members, I shall now propose the question for debate. Be it resolved that the Senate adopt the report of the Special Select Committee appointed to consider and report on a bill entitled An Act to Amend the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters. Senator Ramdeen.
Thank you, Madam President. Madam President, I was privileged to be part of the Select Committee that was given the task to report back to the Senate to consider the bill, An Act to Amend the Offences Against the Persons Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters. And I'm also happy to have been able, as a member of the committee, to report back to the Senate in the time that was fixed, which was a very short time for us to consider the amendments. Madam President, in speaking to the report that is now before the Senate, it is important that we acknowledge that this committee was set up pursuant to recommendations that were made by the opposition for the purposes of bettering the piece of legislation that was currently before the Senate in the form as presented by the Honourable Attorney General. And it was because of the forward-thinking way in which the legislation was presented that we are able today to sit here to debate this report, which I think, Madam President, after the work of the committee, we can all on each bench, on each side in the Senate, say that we have a better piece of legislation if this report is adopted. I can say, Madam President, that the work that was done in the committee in terms of putting together this piece of legislation and making the recommendations for adoption by the Senate is work that I think that the government, the opposition, and the independent bench can all be proud as a parliament that we've been able to accomplish. And I can say that with conviction because I think this is one of the opportunities that we've grabbed hold of, and the contributions by both the government, the opposition, and the independent bench has been able to allow us as a jurisdiction to put into our statute something that no other jurisdiction in the Caribbean has been able to do. And even from the borrowings that we made with respect to the practice directions from the United Kingdom, I think we should be proud as a parliament to be able to enact this piece of legislation if the committee's report is adopted, because what we've been able to accomplish by making these recommendations through the committee is we've been able as a committee to be able to put into law something that finds its genesis, Madam President, in the Criminal Lunatics Act, which was 1800. So you have over 200 years of jurisprudence that we've now finally been able to settle as to what is the correct approach that a court ought properly to take in relation to someone who is before a criminal court on an indictment, and that person has been found to be suffering from an abnormality of mind, and therefore that person is not, the law recognizes that that person is to be treated differently from someone who has all of his senses, someone who is compos mentis. And it is commendable, Madam President, that the government has taken the opportunity to be able to enact in statute what our Court of Appeal has laid down by virtue of a judgment. And I think it is commendable because the approach that the Parliament has taken with respect to this particular piece of legislation is similar to what we strive to achieve as a Parliament. Because if we borrow from the United Kingdom what the position is when you carry a matter all the way to the European Court and you get a declaration of incompatibility where the law does not accord with the Human Rights Act, what you have is immediately Parliament will take steps to fix the law and put into place legislation that puts into effect the judgment of a court. And as a committee, what we have been able to achieve, and as a Parliament, as a Senate, if we adopt this report, what we would be able to achieve is that we have put into statute form what the Court of Appeal has told us. And we have added to that. And I think it is important to recognize that we've added to the aggravating and mitigating factors that a court must take into consideration when a court comes to determine what is the minimum term that a person who has been found guilty on an indictment and suffering from an abnormality of mind ought to take into consideration. And Madam President, like the Honourable Minister of Agriculture, who chaired the committee, I too would like to make some comments about the work of the committee that I think is quite important for us to recognize as a Senate. As I indicated before, Madam President, we have been able to fix the unconstitutionality with respect to the detention of a person who is suffering from an abnormality of mind. The length of that person's indeterminate detention is now going to be determined by an independent and impartial tribunal. And that is a very important amendment that we've made. It will no longer be determined by the President as it was before. It is now going to be determined by a court. And that accords with the rights that are given to each and every citizen of this country, both under the fundamental rights provisions, but more importantly under the separation of powers. So that the length of that person's detention is going to be determined initially by a court, and it is going to be reviewed by a court. And that is put into the law by the amendments that we ask the Senate to adopt. Madam President, one of the very, very important amendments that the committee has made relates to the way in which a judicial officer, in this case a High Court judge, will exercise his powers if an accused person decides to have a trial by judge alone. And one of the most important provisions that we have been able to agree to this committee is that not only would you have due process by virtue of having an extension of your option to have a trial by judge alone, but very, very importantly, this piece of legislation, if it is passed by the Senate, pursuant to the recommendations of the committee, it will be the first piece of legislation that as a Parliament, as a country governed by a written constitution, we've been able to put now into domestic legislation a provision that fixes a time frame for not only a judge to deliver his verdict, but for a judge to deliver his reasons. And that is extremely important. It is a very progressive step as a Parliament that we are asking this Parliament to make. Because whereas in the Summary Courts Act, a magistrate has 60 days to deliver their reasons, one of the main complaints, or one of the principal complaints about our judicial system is the pace at which the wheels of justice turns. And this piece of legislation, if it is passed, is going to be the first piece of legislation where we are going to fix a time frame for a High Court judge to not only deliver his verdict, but also to deliver his reasons. And that is an extension of not only due process and protection of law, it is an extension of the right to a fair trial. We suffer in this country under a constitution which does not provide for a right to a trial within a reasonable time. It is perhaps one of the very few constitutions that does not provide for a right within a reasonable time. And it is commendable that we have been able to present a piece of legislation that, notwithstanding the absence of that right in section 4 and 5 of our constitution, that we've been able to put that piece of that mechanism in this piece of legislation, so that someone who chooses to have a trial by judge alone, at the conclusion, they will have their verdict within 14 days, and they will have the reasons. That judicial officer must produce the reasons for his verdict within 14 days. And that is a very, very progressive step that we've made, and I would like to see that the government can bring legislation so that those who are part of the criminal justice system can be equated with those who are part of the civil justice system, and we can fix a time for judgments to be delivered in a civil matter, so that people will not be suffering under this pain of having the wheels of justice turn at too slow a pace. So if we can follow that, and the Attorney General can look at the Supreme Court of Judicature Act, and perhaps with his advisors bring legislation that can do that, I think it is something that all of us as a country can benefit from, Madam President. Madam President, we have also a very, very important extension that flows from the report of the committee, is that when someone is convicted and a minimum term of their detention is set by the judge who presides over that criminal trial, notwithstanding the decision of the Court of Appeal in Atin, we as a parliament have recommended, as a committee have recommended, that the person who is the subject of the order for detention will have a right to appeal the order from the High Court. The Court of Appeal in the Atin judgment indicated that there was no right of appeal in that matter, but we considered that someone who is going to be incarcerated for a period of time after a criminal trial for an indeterminate period of time, and a judge having the power to determine the minimum term for that person to suffer a period of detention, that person ought properly to have the opportunity to test the correctness of that decision by an appellate court. And therefore, you will see in the recommendations that by virtue of the proposed amendments, we have given that person a right of appeal. Madam President, much has been said about this piece of legislation being trial by judge alone, as to whether it intrudes, whether it infringes upon the right to a fair trial, whether it infringes upon the rights under section 4 and 5. I think that what we as a committee have been able to present to the Senate and the work that we've done, we have benefited a lot from the government listening to the opposition. We have benefited a lot from the government listening to the recommendations that we propose to this piece of legislation. And the piece of legislation that finds itself in the report of the committee is a piece of legislation that, one, provides certain safeguards to the rights of the accused person. It provides certain protections to a person who decides or exercises the option to have a trial by judge alone. And even after that trial is concluded in terms of the evidence and the verdict, it extends the right to the protection of law, the right to due process, and the right to a fair trial to beyond the actual conviction, to the verdict and thereafter. I think that this piece of legislation, Madam President, that finds itself in the report of the committee is one that ought properly to be supported by both the government, the independent bench, and the opposition. I think we've done very well to make amendments to the legislation as presented by the Honourable Attorney General. And I think the report of the committee, Madam President, is an example of what we can achieve when we all work together in the best interests of the people of Trinidad and Tobago. So I wish to thank the Honourable Senator Rambharat for the way in which he conducted these proceedings of the committee as the chairman. I wish to thank Senator Chote for the advice that Senator Chote, the invaluable advice that she gave to us as a member of the committee. I wish to also express the gratitude for having Professor Hutchinson come to before the committee and give of his time, give of his wisdom, and enlighten us as to the way forward in which we could correct the legislation. And I hope, Madam President, that the example that we can use what we've done here in relation to this piece of legislation as an example of what we can do as a parliament together in the best interest of the people of Trinidad and Tobago. And I ask all of us to support the report and to adopt the report of the committee. I thank you, Madam President.
Senator Chote.
Thank you, Madam President. Madam President, when a bill is sent to a joint select committee, I imagine we always expect that it will return to the floor with improvements. So perhaps it is because I stand in a different place from Senator Ramdeen that I don't see that it is necessary for us to offer up self-congratulatory plaudits with respect to our work. We were appointed to a committee and we all worked very hard. I think that the product, which is now before the Senate, certainly is quite different from the initial piece of proposed legislation. It is the first time that I had the opportunity to work with the other senators on such a committee, and I have to say there was a fundamental thing which occurred during the discussions of this committee, which I think ought to chart a way forward when we consider criminal legislation in the future. The fact that the government was open and willing, and I thank the Chairman and the Honourable Attorney General for that, to realize or appreciate that when we speak about this kind of legislation, we have to take into account the mental health factor. I think that was a tidal change in thinking as far as I was concerned, seeing it from a criminal lawyer's perspective. And I think that should certainly be a course that should be recommended in the future for other pieces of legislation. But I certainly thank the other senators for the work that we put in, and I think the product is a sound one, and I ask my colleagues certainly to consider it and support it.
Honourable Attorney General.
Thank you, Madam President. Madam President, for my own part, if I could just make a very short contribution. Firstly, I do accept the caution offered by my learned colleague, Senator Chote, that plaudits are not necessary, but in this particular field of parliamentary practice, I think it incumbent to put onto the record credit where credit is due, because far too often very good work goes unnoticed. If I may firstly express my extreme gratitude to the very, very, very capable management offered by Senator Rambharat as the chair of this committee, notwithstanding the fact that I have moved this bill and I'm in charge of it. I don't stand as a member of the Senate and therefore could not chair it. Senator Rambharat certainly managed the content and material and cadence of the committee with an extremely capable measure. Secondly, Madam President, if I may express a very warm and open congratulations to Senator Ramdeen and to Senator Chote, because they both gave very strong, from the practice of court measure of experience to this bill, and brought forward certainly perspectives of the law which now find themselves in the report of this committee and in the parent law amendments that we now seek to cause, and which I think take us to a significantly better place. Had it not been for the practitioners in this arena stepping forward to give the measure of input that they did, both Senators Ramdeen and Senator Chote, I think that the country would not have taken advantage of such a good opportunity as we have had. And on behalf of the government, I wish to offer my sincere thanks and appreciation to all members for the manner in which this debate and the special select committee was conducted. Permit me just, therefore, Madam President, to add a few remarks to some of the content traversed by Senator Ramdeen, because we are making a significant improvement to certain aspects of the law. It is, of course, in the Offences Against the Persons Act, which we sought to amend in the bill, that we have made a very important improvement by taking into account the Court of Appeal's decisions in Atin number 1 and Atin number 2, as improved by the practice directions coming out of the United Kingdom, which Senator Ramdeen had referred us to. It's important in speaking to the novelty of putting a time frame for the delivery of reasons upon a verdict. And let me translate that. In the Offences Against the Persons Act, we are now saying that the court must deliver a verdict as soon as is reasonably practicable, but in any event that the court should do so within 14 days of making an order. And specifically, when we come to making this improvement, we allow for the factoring of the issue of liberty which we're dealing with in this area of law. I wish to offer a very, again, warm thanks to the Honorable Chief Justice, because in an effort to exercise caution, I certainly contacted the judiciary to ask for the perspective from the judicial point of view as to fixing time frames for the delivery of certain matters. And indeed, the Honorable Chief Justice communicated that because we were dealing with a matter of liberty, that it was only appropriate that we actually agree to put in time frames, and that the judiciary itself would be supportive of that. It's very important to note, therefore, that notwithstanding the fact that we put in the requirement for the decision coming in a particular time frame, we also do allow the court the ability to tell the parties at any point in time that they are running into difficulties, and that the difficulties result in the court needing to move the time frame. But in the simplicity of the new law, we invite the court to convene a sitting of the court, invite the parties to the court, and then indicate such further time frame as will be necessary to deliver the reasons or the judgment upon the verdict. We've sought to balance as well, Madam President, the scarcity of judicial resources. And we do allow in this particular bill for, on the one hand, a time frame for the delivery of reasons upon a verdict of guilt, and the need for the court to keep the parties constantly informed of that position. But what we do as well is to recognize that the not something which will automatically necessarily generate reasons. And so the bill does contemplate the fact that the appeal mechanism, where the DPP rolls up or the prosecution rolls up and requests the reasons for acquittal, it's only at that stage that it actually kicks into the mechanism of producing a judgment at that point. It is useful to bear in mind that judges often start writing judgments as the case is progressing. And therefore, one can only hope that the judiciary would develop a practice to improve the jurisprudence of Trinidad and Tobago by giving reasons simultaneously with verdicts, and more particularly to allow the advancing of our common law and the rationale behind sentencing when we deal with both convictions and acquittals. Madam President, the subject matter, I wish to remind, traverses an aspect of the Children's Act, which again is an observation, is in need of improvement, in particular section 59 of the Children's Act. And I would just like, for the purposes of the record, to certify once again that we certainly do intend to cause an amendment to Section 59 of the Children's Act when we come to treat with an omnibus review of that in the month of September. We've actually prepared the draft bill for that some time now, and we will be seeking to carry through our undertaking that we get that particular position right. Because I think that Act number 12 of 2012, I think it was a simple omission on that part as to how we treat with juveniles in that context. I will now close, Madam President, by again commending all members of the committee and volunteers as well, because Senator Rafool certainly took very useful opportunity of the standing orders to attend every single meeting. I wish to again underscore that this special select committee went to work in a very quick time frame, notwithstanding the passage of public holidays, and fortunately prior to the passage of the tropical storm Brett. I should add, I've just been reminded across the floor that we did cause some amendments to the forms attached to the bill, where we treat with when persons are represented or unrepresented, how those persons are to indicate their positions. And I ask members to note that we have done the consequential improvement to the forms as we have sought to treat with the content of the material which both the Senate considered in the debate, in the Committee of the Whole, and in the Special Select Committee. May I commend this bill and all the effort that has gone into it for the approval of all honourable senators, and I thank you, Madam President.
Senator Mark.
Thank you very much, Madam President. I won't be long. I just want to join my colleagues in recognizing the sterling contributions made by members of the Special Select Committee of the Senate on this very important matter that we had assigned the responsibility to this committee to address. And having regard to what we have been advised have been literally revolutionary breakthroughs for the first time, as articulated by colleagues who have spoken thus far. I think it is commendable, Madam President, to record the Senate and our appreciation as a front bench here, opposition bench, to our colleagues who have contributed. Madam President, I want to indicate to you that the concept of post-legislative scrutiny becomes very critical as we traverse this particular path and journey that we have taken up today. I would like, with your leave, Madam President, to suggest to the Honorable Attorney General and my good friend, the chairman of this committee, who has had a long experience in the Canadian jurisdiction, having lived there for a while, I wanted to proffer to my colleagues the need for us to consider incorporating a provision in the legislation via the adoption of the report before us of a provision, Madam President, that would bring about an audit of the workings of these provisions contained in the legislation via the report, and have the Attorney General's office present that audit on the workings of this piece of legislation, maybe, Madam President, every 3 years. I think that one of the weaknesses, Attorney General, that we have had, and seeing that we are making revolutionary breakthroughs, it may be useful to consider that if we want to ensure that the legislature that is responsible for giving life and passage ultimately to this report and legislation contained therein, we should look at the possibility of allowing the Office of the Attorney General to monitor through a unit within your ministry the workings of this legislation and to provide to the both houses of Parliament a report every 3 years, or maybe you might say 4 years, so that at the end of the exercise, we as legislators and those to come would have the benefit of looking at the legislation in its real dynamic workings, and maybe through your office, recommendations can come for adjustments, for amendments, and even review of the legislation. So, Madam President, I'm suggesting for the consideration of the chairman the possibility of considering a special provision that would deal with a review, an audit via report every 3 years, so that this groundbreaking piece of legislation is not passed, is not approved, and then we do not see that legislation for review in the future. So that is an area I would like to suggest, Madam President, for consideration. And finally, may I also suggest, Madam President, Standing Order 66-1 has been effected. And I believe that it tells us that with the leave of the Attorney General, and whether it is criminal legislation, civil legislation, but once the legislation is of a controversial nature, I would ask the leader of government business to look very carefully at 66-1, because there is a provision in our standing order under 66-1 where legislation can be referred to a select committee. And we are seeing the benefits of legislation being referred to a special select committee and the outcome of those deliberations. So I would ask, Madam President, that that is an area that the leader of government business should pay some attention to, and the Honorable Attorney General, as it relates to the audit/review, should consider, so that in moving forward, we can really do some monitoring and evaluation of this particular legislation, and it is captured under the concept of post-legislative scrutiny. With those few words, Madam President, I wish to thank you very much.
Senator Heath.
Madam President, I crave your indulgence just to make a brief contribution, which I want the Senate to consider, and certainly the mover of this bill as it goes through the process. Trial by jury, where the trial goes through to the end, renders a verdict of not guilty, is not appealable. If, of course, that verdict is guilty, it is appealable, and therefore the accused person can exhaust his appeals all up the way to the apex of our court structure, which is the Privy Council. If in judge-alone trials, on acquittal, it becomes appealable if the judge, if of course there's an acquittal, the state can appeal. What we'll be doing, we'll be creating for that accused person avenues in which the state can then appeal, whereby the other system of the jury, it simply does not now exist. So I don't know if that is now the intention, or it may very well be an oversight that we now need to look into. Because if it is that we certainly want to steer persons into the judge alone trials, I can see certainly one hindrance whereby the accused person is told that if it is you are acquitted, there's going to be avenues for appeals, whereby if you go to trial by jury, if you're acquitted, there is not going to be. And that is something I think the Senate should consider. Much obliged.
Minister of Agriculture, Land and Fisheries.
Madam President, I want to thank everyone for their contribution. Just to address the point made by Senator Mark. Madam President, I myself, on the last sit-in, talked about the importance of not only crafting and implementing legislation, in particular legislation dealing with the criminal justice system, but also using the resources that we have available to us as a parliament to ensure that what we create and set in train is actually implemented. And I used the example of the DNA legislation on that occasion, showing how well-intentioned legislation brought to the Parliament in 1999 still remains unfulfilled in 2017, notwithstanding the replacement of that legislation in 2007. And may I say, Madam President, that there are two areas in which, without doing more on what we've presented, there are two areas, opportunities already available to us as a Senate. And that is first in relation to our ability to ask questions in this House and in the other place, requiring an oral or written response. And that gives the opportunity for anybody who wishes to hold the government to account on the progress made in the implementation of the results for the purpose of accountability and measurement, to ask a question which can be answered in an oral or written way. Madam President, there is also the opportunity through at least two joint select committees, one of which I serve, the Finance and Legal Joint Select Committee, to have the opportunity to call into account the institutions to address any issue, and in particular the progress made on the implementation and the results out of this legislation or any other legislation. There's also a joint select committee which deals with national security matters, and the opportunity arises also for that joint select committee to call the Ministry of National Security or any other related institution to account for progress. I think, Madam President, Senator Mark's suggestion is a good one, but I also believe in the current form, the standing orders provide for that level of accountability and reporting on legislation, and it is up to us as a parliament to hold the institutions over which we have only limited level of control accountable for what we put in train, and to ensure that what we would like to have implemented and what we'd like to have done outside of this parliament actually happens. Madam President, I beg to move.
Honourable Senators, the question is that the Senate adopt the report of the Special Select Committee appointed to consider and report on a bill entitled An Act to Amend the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters. Those in favour say aye. Aye. Those against say no. The ayes have it. The report is therefore adopted. Attorney General.
Caught me slightly unprepared with several matters listed, Madam Speaker. I'm just looking for the procedural paper. Thank you. Madam President, I beg to move that a bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Offences Against the Persons Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters, be forthwith read a third time and passed, pursuant to Standing Order 69-2.
Honourable Senators, the question is that a bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters be now read a third time and passed. Those in favour say aye. Aye. Those against say no. The ayes have it.
A bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters. Business. Government Business Bill, second reading.
Honourable Senators, the debate on the second reading of the following bill, which was in progress when the Senate adjourned on Tuesday, June the 20th, 2017, will be resumed. A bill entitled An Act to Establish a System of Plea Discussions and Plea Agreements and for Matters Incidental thereto. Senator Sturge.
Thank you, Madam President, for the opportunity to join this debate. Madam President, I am not satisfied that the Attorney General has provided this Senate with a satisfactory explanation as to what is wrong with the existing Act. That's the 1999 Act. And I hope in wrapping up he can tell us in detail what exactly is wrong with the 1999 Act. This 1999 Act, you would recall, Madam President, was piloted by former Attorney General Mr. Ramesh Lawrence Maharaj. And Mr. Ramesh Lawrence Maharaj, you would know, up to the time when he was appointed or elevated to the position of Attorney General, up to that time he was perhaps the most decorated attorney at the criminal bar. Up to the time of his appointment and before he piloted the existing Act, the 1999 Act, he was also one of the more decorated human rights and constitutional lawyers. So we have a man who was decorated in both criminal law and constitutional law, particularly human rights, with an understanding of the system as it relates to plea bargaining and plea discussions and immunities and so on as they existed then and as they continue to exist now, passing a piece of legislation, and now we are being asked to repeal it. Now, why, I have to ask. And what jumps out at me, and I am leaning on what I learned from the symposium held at Radisson with respect to this very issue, and what I read in the Hansard in the other place. And what is clear is that from 1999 to present, 4 consecutive directors of public prosecutions found it necessary to stay as far as possible from that 1999 Act. But what exactly was wrong with it? I'll go into detail after. But what immediately jumps out at me is this. The 1999 Act had sanctions for prosecutors who misconducted themselves when it came to plea discussions and inducements and so on, so that prosecutors could be charged with offenses, and they were criminal offenses which carried sanctions. This act, Section 8, I believe, simply says that a prosecutor shall not initiate or participate and so on, and it goes on about entering into plea discussions and inappropriate inducements and so on. And of course, what is an improper inducement is defined earlier in the Act. But when you look at Section 8, the prohibition against plea discussions in certain circumstances, and when you look at the Act generally, unless I missed it, there is no sanction. Now, how does one, I know legislation can be both facilitative and it may exist to deter certain types of behavior, but how does one simply say you shall not engage in improper inducements and so on, and you leave it without punishment? That makes absolutely no sense. But you have to wonder why 4 consecutive directors of public prosecutions felt it necessary to stay away and operate outside of the Act, preferring to use persons offering them absolute immunities to testify or conditional immunities to testify. Because if you go that route and you don't go through the Act, then there's no chance of sanction and imprisonment. Because you see, the thing is, these directors of public prosecutions must have appreciated that this type of legislation puts you in a way, puts you in a situation where you are dealing with a snitch, where you are dealing with the lowest sort of figure in the criminal world.
That's right.
Where you are making a deal with the devil. Because, you see, the thing is, they would hold these persons up, these persons who are snitching on their friends, hold them up to a jury and say, believe him. Where would we get the evidence from? We can't get it from a Roman Catholic priest because he doesn't take part in criminal business. So the only person we can rely on is somebody who's part of the criminal enterprise. And they'll tell a jury he must be speaking the truth. But the same prosecutor who's holding this snitch up to a jury and telling the jury to believe him wouldn't dare deal with this snitch under the 1999 Act, because he knows this snitch, since he's the type of person who would switch on his own confederates, is the type of person who would turn around and level allegations against the prosecutor. So they are afraid to touch this man. He is good enough to put before a jury to convict his confederates, or who he claims to be his confederates. But he's not good enough for me to deal with, because if he turns around and makes allegations against me, then I might find myself on the business end of a criminal charge. So this bill here removes the sanction so that the prosecutor is now free to engage, to initiate plea discussions with this very despicable creature, knowing fully well that he can make whatever allegations he wishes, that you can't touch me, you can't do me nothing, because we repealed the 1999 Act. So what is there to prevent a prosecutor, and we have prosecutors, mind you, I wouldn't go and call names because of where I am, but I can call it outside of Parliament and not be afraid of defamation. But we have prosecutors who are no different to Michael Hill, Queen's Counsel. I'm quite sure if one throws his mind back to Michael Hill was the one who prosecuted the Guildford Four. Wow. I'm sure you remember the movie In the Name of the Father. Quite a boring movie, but at the end of it, these persons were innocent. And it was Michael Hill, the prosecutor, in collusion with the police, who had a file that would have shown that the Guildford 4 were innocent, that the Maguire 7 charged with related offences were innocent. And you know what he wrote on the file? Do not disclose to the defense. So, English people look at Irish people in a certain way. So it's okay to send Irish persons to prison because we have a problem with bombing. And we have to show society that we are doing something pretty much like the situation that we are in. And at the end of the day, innocent persons go to jail. That cannot be right.
Well said.
And that is a real situation.
Well said.
I'll call the name of a case, a local case. It has finished. And Senator Chote knows the case well. It's Barry Brown and others. And we made fun of the prosecutor. Because little did the prosecutor know that the police gave us the statement in advance, and we knew that the incident didn't last more than a few seconds, and the witness had only seen the men when he looked back over his left shoulder and whilst he was running away and receiving gunshots. By the time the prosecutor came to trial, to the PI, and was leading evidence, what was 6 seconds turned into half an hour. What was a story of this man, this witness saying, I know one of them, I know the other one, I don't know the third one, I didn't see him. Or the short point is, it turned out I knew them real good. I used to go home by them and eat. And it didn't last 6 seconds or 10 seconds, it lasts 30 minutes. And they empty a machine gun on me, and they reload, and they shoot again. And guess what? We called for the station diary to find out if that prosecutor had gone the day before the witness testified to see the witness. And you know what they said? That diary has been destroyed.
Wow.
That case went to 3 trials, and that diary apparently was destroyed. And the prosecutor stood up and he re-examined the witness to say that he did not visit the witness and they had no conversation before he testified.
Wow.
But when the station diary resurfaced in another murder, luckily I was in it, and I was able to say, is this the same station diary was destroyed? Then it had to be produced before His Lordship Muhammad in the 3rd trial. And in the 3rd trial, we saw clearly the prosecutor had visited the witness the day before he testified. And what was a fleeting glance turned to half an hour. What was an identification case turned to recognition. All the loopholes cured. And he's not the only one. The investigator was the other one. And you know what happened to both of them? Nothing. Just like Michael Hill, nothing. Zilch, 0. In fact, that's a lie. You know what happened to them? They got promoted. They got promoted. In the case of the police officer, just one rung below Commissioner of Police, and he stood a chance of becoming Commissioner of Police. And I want to tell you something about that chap. There's not one, there's not two.
The bill is not on, you have to deal with the bill. The stories that you're giving that tie into the bill are relevant, but you can't go on, okay?
Yes, I'm not going on. I'm going on to make a point very shortly, which I'll show in the bill. It's necessary, but I take your guidance. There are 3 or 4 judgments against that particular police officer, where High Court judges said he should be charged with criminal offences for misbehavior in public office, for conspiracy to pervert the course of justice, and so on. And he moved from sergeant right up to deputy. And he had justices of the peace, because justices of the peace feature in this, and he had justices of the peace, some who held themselves out and who thought of as men of impeccable character. The judges also made findings against them and said they were colluding. So, let's move on to the bill. Because all this is necessary. I just mentioned the Central Park jogger to my learned friend, who may go into it in detail, because I want to ask two questions which this bill deals with. Because you see, you are talking about inducements and you are talking about suspects in the context of plea bargaining, but the jurisprudence regarding suspects and inducements really comes out of what is known as the judge's rules, which really relates to persons who give statements in custody and which are used against them as confessions, and which is very possible in this bill. And I'll say how. But in going into it, I have to ask, and you see most people don't know, the criminal element in any society is usually part of a single-digit percentile of the population. It's a very small class.
That's right. That's right.
So whilst most of us would never commit a criminal offense, as F. Lee Bailey says, I cannot guarantee you that you will never be charged, because innocent people have been charged. In this country, several innocent people, in fact, high profile, let me give you one. Junior Sammy came close to getting a murder charge from a man who I'll refer to when I deal with one of the clauses in this bill. Very close, because of plea bargaining. Very close to a murder charge.
Ask you, you can make reference to the matters, but could we desist from calling names?
Yes, please.
Yeah?
Guided. So, what I'm saying in essence, you can say with certitude that you'll never commit a criminal offense. That doesn't mean you'll never be charged with one. That's the reality. Which brings me to the second question. And I ask rhetorically because I know the answer. But sadly, many people don't. If I ask the question, would you confess to a crime you did not commit?
No.
I'm sure you'll say no. You know what the answer is? You know what the truth is? Yes, you will. And that is the experience of Central Park, the Central Park joggers. Charged with offenses they did not commit. Confessed. And only when the DNA came back, then, and you know what? Nothing happened to the prosecutors, nothing happened to the police. So let's go into the bill. And before I go into the bill, let me regale the Senate with certain rules that have been in existence for more than 50 years in this jurisdiction. It's called the Judge's Rules. And if I may be permitted to quote from it. Because you see, there's something very dangerous about this bill that I've seen only in certain questionable jurisdictions, and the United States is a questionable jurisdiction, leading the world in wrongful convictions. The United States and Japan, they lead the world in wrongful convictions, and that's the jurisdiction we hold up as the best. And we are thankful to Peter Neufeld and the Innocence Project and these lawyers who basically know how an innocent man can end up 30, 40 years behind bars and so on. And that's the danger of this bill. So with all, we might have the best intentions, but as they say, the road to hell is paved with good intentions. So let's go to the Judge's Rules, because the Judge's Rules are a safeguard. And the Judge's Rules deals with two concepts that find themselves in this bill. One, the concept of what is a suspect, and one, the concept of inducement. And the concept of inducement, in essence, is that the judges would not allow into evidence any statement made by a person in custody where it is not voluntary, in the sense that it has been obtained from him by fear of prejudice or hope of advantage, exercised or held out by a person in authority. A prosecutor is a person in authority. A police officer is a person in authority. But right in Appendix A, Rule D, and this becomes very important as a precursor. Appendix A, Rule D. When a police officer who's making inquiries of any person about an offense has enough evidence to prefer a charge against that person for the offense, he should without delay cause that person to be charged or inform that he may be prosecuted. And when Appendix D, Appendix A Rule D kicks in, then the judge's rule, Rule 3, A and B kicks in. It means if you have enough evidence to charge someone, he's no longer a suspect, he's referred to as an accused. And it says, when a person is charged with or informed that he may be prosecuted for an offense, he shall be cautioned in his following terms, which is not necessary. The B part is, it is only in exceptional cases that questions relating to the offense should be put to that accused person after he has been charged or informed that he may be prosecuted. And such questions may be put where they are necessary for the purpose of preventing or minimizing harm or loss to some other person or to the public, or for clearing up an ambiguity in a previous answer or statement. So once you have enough evidence to charge a person, he's no longer a suspect, which is a new bill. And once you have evidence to charge him, you have to tell him that we have evidence to charge you and we are going to prosecute you. And when you tell him that, or even if you don't tell him, once you have that, then you cannot ask him any more questions unless 3 situations arise. That's right, bro. This bill has eviscerated and emasculated the judge's rules that exist to protect the citizens of this country by inserting into the bill suspect. So let me tell you what is a suspect according to the judge's rules. According to the judge's rules, Rule 2, as soon as a police officer has evidence which would afford reasonable grounds for suspecting that a person has committed an offense, he shall caution that person and so on and tell him the caution. But you see, the thing is, it's evidence which causes the police officer reasonable grounds to suspect. Not to charge, to suspect. Which means you have nothing on the man. And when you have this, where all you do is suspect, and you don't have evidence to charge him, if you have evidence to charge him, it's Rule 3. But if you don't have evidence to charge him, but you suspect he might have committed an offense, then you hit him a Rule 2 caution, which in essence, without reading it out, tells you, shut your mouth if you know what is good for you. It means in essence that if you don't shut your mouth, if you give up your right, you're against self-incrimination, and you choose to talk, whatever you say would be put down in writing and given in evidence. It sounds American. The Americans actually got it from the English. So imagine, let's look at the bill now. You have a suspect. Why are you entering into or initiating or engaging a person who you have no evidence against? Why are you seeking to initiate plea discussions with him? Why are you engaging in plea discussions with someone who you have no evidence against? So you can word the definition section how much you want. You can't get rid of the judge's rules and the case law and all the protections saved by 1976 and so on and so on. You can't get rid of it. So let's look at the person in custody who is a suspect, who they have according to the judge's rules, who you have no evidence to charge, you have nothing on him. And look at his mindset. And the case of Ramdeen Pert comes to mind because the Privy Council spoke about the mindset of a person in custody. So what is the mindset of a person in custody? The first thing he's thinking, well, I wouldn't be in custody unless the police had something on me. Yes. And that may or may not be true. Maybe he did something. But a lot of the times, in our jurisdiction, nothing. But you are in custody. So imagine you're in custody. The first thing you are thinking, the police have something on me. Else I wouldn't be here. Then according to this bill, in comes the prosecutor to initiate discussions about a plea deal with you. Asking, what do you have to sell? Or rather, who do you have to sell out? Because I have a deal to offer. And he will be thinking, well, one, I'm in custody, something must be wrong. And two, now a prosecutor is coming to talk about plea. You know what he's thinking one time? I am in serious trouble. And what do they say? A drowning man will clutch at a straw.
That's right.
Shabadine Privy Council. So in that sense, he's thinking now, but I don't know what they're talking about. They're asking all these questions. I am able to piece together from the questions what they are talking about and who they want. But I don't really know nothing. But you know what? I'm in jail. I'm in custody. What now? And those who cannot afford a lawyer will have a legal aid lawyer sent for them. You know who the legal aid lawyers are? Who go to station visits? They are lawyers who are looking to make $1. So you have a green lawyer who has no experience at the criminal bar turning up at the police station to get his $1,500 from legal aid, has a conversation with the suspect. He knows no criminal law. He hasn't been in practice very long. He's up against a police officer who has 15, 20 years experience and knows how to run rings around him. If the police officer open him out too hard, he frightened and he ready to run out to the people's police station. They have no mettle. And that is what you send to defend a citizen. And worse yet, when the prosecutor comes in, the prosecutor is somebody day out, day in, day out in the magistrate's court practicing what? Criminal law. He knows this thing inside out. Up against a green man, that's not equality of arms.
No, sir.
That's advantage.
That's right.
So unless you fix the bill and put in that the lawyer who comes to the police station has to be somebody who practices criminal law with a certain level of experience, particularly for murders, this will easily be struck down. Now, hear this. If you have nothing on this suspect and you do the right thing, the police do the right thing and tell him he has a right to remain silent, and he does, what does that mean for this bill? If he exercises his right to remain silent, you get nowhere. The entire bill falls down because you have nothing on him. He's a suspect. And in fact, the judge's rules, when you look at the cases, you can't even engage him in any discussion because you have nothing on him. So you define it how much you want in this bill. When you reach the court, the judge would say, listen, the fact that you approached a man and had a discussion with him when you had nothing on him, that in itself is an improper inducement, and you cannot legislate that. But what if you do have something on him? You know what you're asking him to do? You're asking him to sell a story.
That's right.
Now, you know what this is? This is classic whistleblower legislation through the back door. So this is a chance when the Attorney General wraps up to tell us exactly why whistleblower is no longer coming to the Parliament. Because you see, the thing is, just like whistleblower, this will fail for breach of Section 4. So you need a 3/5. And I dare say, just like whistleblower, even if you get the 3/5, it would fail still. Because this is not the type of legislation you would pass in a society that has respect for the rights of individuals. If you have respect for the rights of an individual who may very well be innocent, then you wouldn't be engaging him knowing you have nothing on him. That is dishonest. Twist it how you want. It is dishonest. It is low. Now, let's move on. Because you see, the thing is, and if I can backpedal, when I came out years ago, almost every other case had a confession. Everybody seemed to be confessing. But when they reached the court, they said I didn't give that statement, or I only signed it because the police tell me, well, if you don't sign it, you'll get charged. So, save yourself, which is an inducement. And routinely, the judges would let it in, and the jury would kick it out. So you come with, and all you had at the end of the day, most of these cases I practiced, most of these cases with confessions, the only evidence you had was what? the confession itself. So you induce a man to incriminate himself, which is a breach of Section 4 and his right to silence and so on, when you had nothing on him. And then you go to court and a jury is looking at that and saying, you really feel you could fool me with that? And not guilty. Routinely. I'm sure Senator Chote can bear me out on this. Routinely. Until at one point, Justice Narine lamented that whenever a case depended on the credibility of the police, you're sure to get an acquittal. So let me join Mr. Gaspard in saying that if you want to raise the rate of conviction in the criminal justice system, first thing you have to do, you get scientific evidence. You can't depend on the police or the word of the police. Second thing, you have to fix the credibility problem of the police. Because people don't trust the police, and for very good reason, and I thank Senator Rambharat for saying so. Because I don't trust them either. But I can't go into cases because I had a whole lot I would have wanted to regale the Senate on, so that we'll know that Central Park is not an American thing, and Birmingham 6 is not an English thing, and that we are better than them. We are far worse. But you see, this makes no sense to none of us because we are all connected, and if the family get charged, we can go and talk to somebody and get released. But the average man have no connections. He have to go and find liar fee. And you see, this is a reality because somebody might come up and say, all that Mr. Sturge is talking about relates to confessions and not plea deals. You see, the thing is, with respect to this, is you may have a situation where a man would say, I'm entering into plea discussions, and then say, you know what, I changed my mind. But they already have a statement from him. They use that statement, although the bill says you're not supposed to. All of a sudden, the police officer will say, we had no plea discussions with him. It was the normal thing where we investigate and we take a statement. No prosecutor can come, nothing like that happened. Just like in Sebastian Joseph and Andy Brown and others. And before you know it, you talk your way to death row. That's what is wrong with this bill. But let me tell you what is also wrong and a travesty, Madam President. How much time I have? Madam President, can I ask how much time I have, please?
You have until 9 minutes to 5, 4:51.
Oh dear. Thank you. There's something else very troubling about this. You see, we use some Americanisms in here. In the United States, the prosecutor can get involved at the stage where he's initiating plea discussions and so on. And what you have to take into account is that the prosecutor in the United States is very different to the prosecutor in this jurisdiction. The prosecutor in the United States works for the district attorney. The district attorney is an elected official. And if he wants to be re-elected, he better keep the conviction rates up. So that is why in the United States, you have prosecutors getting involved at the investigative stage and telling the police how to fix things because they have an interest in getting a conviction so that their district attorney can be re-elected to another term. We don't have that here. And those same attorneys in the states are the same ones who are involved in all of these cases which are being overturned, where men are spending 20 and 30 years in jail for crimes they did not commit. So here, what's the problem here? The office of the DPP and his prosecutors, they are not an extension of the police service. They're not part of the gang. The office of the DPP exists not only to protect persons from political prosecutions, it exists to protect ordinary citizens from police officers generally. So the office of the DPP is a check and balance on the police. So the office of the DPP, how is he going to get involved in plea discussions? That prosecutor who gets involved in that, you know what happens to him when someone else is charged? He is a witness. He's a witness who can be cross-examined, allegations can be put to, and when you have him saying something that is different to the snitch who's saying something else, then who do you believe? And you put that prosecutor in the invidious position where his reputation is at stake. So first things first, when he comes to prosecute you, he's a safeguard. Because in our jurisdiction, if the police have acted improperly and it comes to the attention of a prosecutor, he has a right, and it has been done several times. I want to call the name in praise, Gerald Joseph, former prosecutor, who stopped cases because police officers admitted to fabricating evidence. So if a prosecutor like Gerald Joseph is part of initiating plea discussions, he becomes a witness. He can't stop nothing. So that safeguard is gone. But then the DPP who is initiating this thing is a party to the proceedings. So how is he party to the proceedings and then coming before a jury and saying, I have no interest to serve, I am a minister of justice, I have no interest in the outcome, yada, 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 like they all say. How can they say that with a straight face? And you are putting them in harm's way for allegations to be made against them by the snitch, and when the accused person...
Senator Stage, you have 5 more minutes.
Yes, when the accused person comes to court, he has to defend himself, which brings me speedily, because I actually, I can't believe I'm not even 1/10 true, but sealing of the deal. Something must be wrong with that. In the interest of transparency, you shouldn't be sealing anything. Because you are sealing something which is a statement this snitch has given, which ought to be available in full detail to counsel for the accused who are snitched upon to use it and say, this is inconsistent with what you are saying now. Why are you also hiding or sealing convictions and so on and so on? They always say, you want to know if to believe a message, then you have to know about the messenger. So we can't hide these things. If a man comes to you in white robes and says, blessed are the children to come unto me, you'll believe he's Jesus Christ, when he might very well be a pedophile? Why are he suffering children to come unto him? That's what you'll have to ask as a defense lawyer. So let me, in adding a word of caution, advance something. There's a legal unit in the police service with police officers. Instead of having the prosecutor initiate discussions and then have to turn around and prosecute or be a witness, let the police officer, who is a lawyer in the police service, get involved. If you're afraid the police officer, the investigator, and you have every right to, and you want somebody independent, he must be independent of the investigation. He's learning law, a JP is not. I think the JP should be out of this completely. And I don't think any sort of discussion should arise in the absence of an attorney at law. None. Don't initiate, don't encourage, no nothing. Because you are dealing with what they say, the scum of the earth, who will turn around and bite you. Let me see how quickly I can, no sanction, jeez, so much to see. Right. And lastly, you see, the thing is, you have to understand where we live and the context of what happens in the criminal world. Many people are holding themselves out as witnesses to crimes that they themselves committed. And they'll know all the detail and sound convincing because they were there committing it. I see Senator Chote is nodding in approval. That is what is happening. And they are saying, I was there with X and Y and we murdered Z. Right? And they're saying, I was just there as a bystander. And then the poor accused have to come and say, me, how I could be anywhere with him? We are enemies. He's Rasta City, I'm Muslim. And then hope that the jury could believe him and adhere to the judge's warning that he always gives in cases like this for a special reason. The warning is, members of the jury, don't readily or easily rely on the statement of that snitch. It is dangerous to convict on the uncorroborated evidence of that snitch. And that usually is enough for a jury to say, I have reasonable doubt. So you want this to work? Do not offer deals to persons who you are not sure about. They might be principal offenders. You shouldn't offer it to persons who are bargaining for other offenses of violence. And you shouldn't offer it at all unless you have scientific evidence to corroborate what they are saying. If you are not doing that, then all of this comes to naught. Brilliant attempt, but at the end of the day, it would be zero. I fear that I probably have about 30 seconds, in which case I thank you very much, Madam President, for allowing me the opportunity.
Senator Shrikissoon.
Thank you. Thank you, Madam President, for recognizing me at this time to contribute to this debate, of which a lot has been said. Madam President, as I begin my presentation this evening, I want to say that I understand the heart of the government through the Attorney General in laying this piece of legislation and understanding that there's a challenge before his government and even the judiciary, and that the tabling of legislation and the suite of legislation that we're seeing coming to the Senate is most certainly guided towards an attempt to resolving or addressing some of the challenges there. So with respect to the intent of the legislation, I most certainly understand. And however, when I listen to the contributions of others in the House, I would like to see, from my perspective, not having a grounding in law and knowledge of it or practicing it, but hearing of the practicalities that occur within the system, I am somewhat confused, honestly. I'm unable, given my lack of legal experience and knowledge, to really make a definitive statement on this piece of legislation, given the experiences that others would have shared. So in my presentation this evening, I will briefly comment on the area of the law, and then I will just make a few specific comments with respect to the bill itself. But I would like to say at this time, especially given the practicalities, and from Senator Ramdeen's presentation, where he did say that he would like to circulate, or he does have 25 amendments to the law, I'm saying from my end, I really cannot make a definitive statement on this piece of legislation at this time. Madam President, when you look at the concept of plea bargaining and you listen to some of the statistics laid by the Attorney General, I understand the challenges that is confronting the legal system in Trinidad and Tobago. And I would like to say at this time as well, with respect to this, if there is a backlog of cases and we're trying to dispose of cases at a faster rate, then why the pieces of legislation to aid the efficiency of this process and not confront the main issue, which would be the resources available to the judiciary at this time? I'm just asking that question. Why is it that we have to go through multiple routes to ensure that we get a smooth and efficient flow through the judicial system? Is it in any way possible that we can equip the judiciary with the resources required so as to allow a smooth transition and an efficient flow and a quicker disposal? I'm just asking at this time whether or not that's possible. And if it's possible, then do we need all the other pieces of legislation to try and create arteries that will get us through a system? I'm really unsure. With respect to plea bargaining, I'm also aware that there are some shortcomings to plea bargaining. And as Senator Sturge would have said in his presentation as well, plea bargaining would involve the police being involved in a bargaining process, and you could have coercion there. You can have a court in a plea bargaining, the court's reputation in plea bargaining is somewhat impugned, because what you have is a person accepting guilt for which he may have been found not guilty if a plea bargain is given to him or offered. And then you have corruption among the forces, which will ultimately lead to a conviction, but that is not substantiated or may not be fair. What about conviction of the innocent? An innocent man pleading guilty to an offense just so that he can have a reduced sentence with the opportunity to get out more quickly. What about inconsistent penalties? Because a plea bargaining process is an aspect of negotiation. So one offense may attract a certain sentence in a plea bargain, and for the same offense in another situation may have another. So there's an inconsistency of... And I'm saying this, and I will touch this point a little bit later. What about lighter penalties for those who can afford it? And I'm a little concerned about that as well, because there are those who may have the capacity to influence a decision or obtain a plea bargain given the access to resources that they would have. And so I'm saying, with respect to plea bargaining, while I understand the intent of the government with respect to the system, there are shortcomings that we also need to address, and then weigh the balance to determine whether or not the shortcomings really outweigh the potential benefits that we seek to achieve, which in my view can also be addressed by directly confronting the issue and providing the resources to the judiciary. That's my position on that. However, given that the bill is before us, I've been asked to look at the bill, and obviously my contribution is geared towards the bill at this time. So I'm going to say, with respect to the bill before us, Clause 1 of the bill deals with a short title and commencement of the Act, and Clause 2 of the bill provides interpretations and definitions. One of the definitions that I would have had a little problem there with is that of the victim impact statement. And the victim impact statement, according to the bill here, refers to a statement made by a victim which is provided to a prosecutor under Part 3. That's in the law. That's in the bill before us. Victim impact statement means a written statement made by a victim which is provided to a prosecutor under Part 3. In my mind, it does not tell me what it is. A victim impact statement means a written statement made by a victim. I'm not sure on the legal drafting and the terminology, but from my teaching or schooling, you don't use the term in the definition when you're trying to define. And I have a little objection with respect to that. With respect to Clause 4 of the bill, 4B of the bill, the prosecutor agrees to take a particular course of action and outlines 9 points. The prosecutor agrees to take a particular course of action, and this is with respect to a plea agreement. And I'm just raising an issue here, just for clarity. All of the 9 are linked by, between 8 and 9, the word and. And I've been hearing in the House that the word and can mean and, it can mean or, and it can mean and or. But when you read 9 clauses and the second to last links the last with the word and, it gives a general impression that all clauses must be met. And so I just raise it as a flag to say whether or not it's and or it should be or. Not sure. And I ask that question. But getting more specifically into the depth of the bill, Clause 4B, Part 7 speaks of, and this is when this falls under when the plea agreement is being negotiated, an understanding that a conviction pursuant to a plea agreement will not be used as evidence of bad character at the trial for a specified offense or for any other offense. I am saying first, if it is that we're in a plea agreement and we're negotiating a way out of guilt and a sentence, then how can it not be used as bad character? But more so, the latter words, or for any other offense. How can a plea agreement where bad character is not being proposed, how can a plea agreement have a bearing on another unrelated offense? I'm really concerned about that, and I don't think that we have the capacity or the wherewithal to negotiate a plea agreement with a condition that exists on another offense. I have a problem with that. With respect to Part 5 of the bill, Clause 5 of the bill, Madam President, Clause 5 of the bill speaks to a plea discussion, or the plea discussions, and a plea discussion may be entered into at any time before conviction. And Clause 5 outlines the various times at which the plea agreement could be entered into. But if you look at clauses 6, 8, 9, 10.1 and 10.2, it all provides conditions where the prosecutor can actually engage in plea negotiations or the conditions under which. So here it is, we're seeing in clause 5 that a plea agreement can be entered into at any time, but the remaining clauses in that section really pertains to the actions of the prosecutor. And so I ask the question, at what point in time can an accused engage or signal his intent to have this plea discussion? At what point in time? And I don't get that clearly from the bill, although clause 5 is saying it may be held or concluded at any time. So I am asking, sorry.
I should let you finish your sentence. Or, all right, just finish that sentence and then I will take the suspension.
Oh, sure. Okay, thank you, Madam President. So I'm just asking the question with respect to this point, that can we consider including a specific clause that says an accused person may at any time before judgment and in accordance with the provisions of this act enter into a plea negotiation for the purpose of reaching an agreement? That is with respect to that point.
My error, Senator Shrikissoon, we will be taking the suspension at 5:30. I forgot that we started at 2:30. My apologies.
Thank you, Madam President, and I'm so guided. So I would, right, so I should be able to finish just before the tea time. So again, just to recap on that point briefly, it's saying I'm not sure in the plea discussions from clause 5, part 2 of the bill, where it specifically gives the accused the right to actually initiate the plea discussion. And I'm asking, if this be the case, can a consideration be given for the accused and to word an amendment or an inclusion to say an accused person may at any time before judgment and in accordance with the provisions of this act enter into a plea negotiation with the public prosecutor for the purpose of reaching an agreement. In my mind, this would give the accused an explicit option to engage in the plea agreement. Part 3 of the bill, Madam President, pertains to the victim impact statement. Clause 13.1 and 13.2 of the bill says that every victim has the right to provide a victim impact statement. 13.2 of the bill says, before a plea discussion is concluded, the prosecutor shall inform the victim of his right to provide a victim impact statement. My interpretation of this is saying that a victim impact statement is only required when a plea discussion is being engaged or plea bargaining is being engaged into. Clause 16 of the bill introduces a timeline under the victim impact statement, 16A, where a victim is a child under the age of 14. And 16.2 says, if the child has attained the age of 14, then the victim along with the person shall produce the victim impact statement. What is my point? My point here is saying, if the victim impact statement only comes into effect with respect to the plea bargaining, and we're unsure when this plea bargaining process is going to be initiated, then given clause 16 is saying a victim under the age of 14, I'm asking the question, at what point in time is the victim's age relevant? Is it at the time of the offense? Is it at the time the victim impact statement is being prepared? What is it? When does the age of 14 years old become relevant to the victim impact statement, given that there is no definite time for the victim impact statement to be given? Because we are unsure when it would be required, given the plea agreement can occur at any time. So I'm just asking the question here with respect to the age. With respect to clause 18 of the bill, and clause 18 of the bill I have a little concern with. It says here, and it refers specifically to the contents of the victim impact statement. 18.1 says the prosecutor shall ensure that a victim impact statement complies with the requirements of section 14. 18.2 of the bill says, if the victim impact statement contains material that is not permitted under section 14, the prosecutor shall redact, if that my pronunciation is correct, that material from the victim impact statement before it is filed with the court. And that word redact means edit, revise, or remove. I'm asking the question, why should a prosecutor have the capacity or the power to alter the statement of a victim? I'm not too sure if that makes sense in my mind. However, if we look at section 24.4 and 24.6 of the same bill, it says here, if the victim's impact statement is filed with the court shall consider the views expressed in the victim impact statement before accepting or rejecting the plea agreement, and the court may accept or reject all or any part of the victim's impact statement. And 6 it says, 24.6, where a victim impact statement contains information that is not permitted under section 14, it is in the discretion of the court. It should not be included in a victim impact statement. So if the court is ruling on a victim impact statement, then why is the prosecutor getting involved? One, in my mind, he shouldn't be, and 24.4 and 24.6 already deals with the content of the victim impact statement. So I'm not seeing or gathering the benefit of having 18.2, where the victim impact statement, where the prosecutor has the power to edit or redact. I'm not seeing that at all. So I really propose that with respect to 18.2, that it should be removed, because in my mind it is adequately addressed in 24.4 and 24.6. With respect to 24.5 of the bill, clause 24.5, and here it says the procedure at the pre-agreement hearing, there was a particular point that Senator Rambharat alluded to that occurred in the other place, and he was saying that there was some requirement or an interest expressed for the victim to be cross-examined, if I'm correct. And 24.5 says an accused person may, with leave of the court, cross-examine the victim. I'm asking, if the victim is represented, if the accused is represented by an attorney, would the attorney also have the opportunity to cross-examine the victim? Because 24.5 is saying an accused person may, with leave of the court, cross-examine the victim. Should it also consider or give consideration to those represented by an attorney? Madam President, clause 24, 25, and 26. They all deal with the plea bargaining process. 24 deals with the procedure of the plea bargaining. 25 deals with the plea agreement not binding on the court. And while 24 talks about all of the conditions that must be met for the plea bargaining agreement to be engaged into, 25 is saying that the court may reject a plea agreement, and 26 says if the court accepts the plea agreement. Where am I going with this? I am not seeing where the court adequately addresses the information in front of it or available to it and pronounces that all conditions of the plea bargaining process has been met. I don't think so. And therefore, I am asking, with respect to the court pronouncing specifically on the conditions, I am asking that some consideration be given to a clause that just may state, a court shall, before accepting a plea agreement, make a determination in the open court that 1, no inducement was offered, 2, there's a factual basis upon which the plea agreement has been made, and 3, acceptance of the plea agreement would not be contrary to the interest of justice. I am saying if the court if the court has to deliberate on whether or not a plea bargain agreement should be accepted or not, it should also be explicit in the facts that is before it, and explicitly state why, or explicitly state that the conditions for the plea bargaining process were met. Clause 25 of the bill, 25.1 of the bill, also talks about the court rejecting a plea agreement. And it says here, the court may reject a plea agreement entered into between the prosecutor and the accused. Clause 25.2 of the bill says, notwithstanding subsection 1, where the court makes a determination that there was an improper inducement offered to the suspect or the accused person, the court shall reject the plea agreement. Now, 25.3, this is my concern. Where a judge or magistrate rejects a plea agreement, the bill is saying, under subsection 1, the judge or magistrate shall, in an open court, inform the accused person of his right to be tried before another judge or magistrate, and within 7 days of the rejection of the plea agreement, provide written notification to the Director of Public Prosecution and the accused person of reasons for rejecting the plea. I am saying if a plea is rejected and reasons are being provided both to the prosecution and to the accused, and that person still now has to go before a court to be tried, are we not prejudicing the accused by providing reasons why his plea agreement was not met, and then have him go to trial, and this information is now made public? I'm asking the question, is the interest of the accused well secured or represented in disclosing facts why a plea agreement was not agreed to by the court or accepted by the court, and then submit him to trial? I don't think in my mind it's fair, and I'm just asking. Clause 3 of the bill talks about this bill shall be applicable to all offenses, summary and indictable. And I have a concern with that as well, because there are certain activities or criminal offenses in this country that carry significant penalties. Murder, for example, is death by hanging. And I just looked at the offenses and penalties by the FIU for anti-money laundering, or the anti-money laundering laws. And it says here that money laundering as an offense carries $25 million as a penalty and 15 years imprisonment on indictment. I am saying someone committing an offense like this or charged with an offense like this, should they really be subject to plea bargaining? And I have a concern about that as well, because these are grievous offenses that need the attention of the court. And a plea bargaining is just an easy way out of a significant offense. So, and the thing about it is, if you're committing an offense such as money laundering, it means that you have access to resources. So in my mind, it kind of compromises the entire justice system with respect to grievous offenses. And so I'm asking, if it is that plea bargaining wants to be engaged, can we look at the fines of offenses, the term of imprisonment, and limit the cases for which, or the offenses for which plea bargaining is made available? And so whether it is by a nominal value in terms of fines, or a time for imprisonment, meaning 5 or 6 or 7 years, no offenses beyond a certain nominal value of a fine, or that would require a certain sentence beyond a certain number of years, should not be eligible for plea bargaining. That's with respect to those clauses. With respect to clause 7 of the bill, clause 7, no proper inducement shall be used to encourage an accused person or suspect to participate in a plea discussion. But if we go to the original bill, which is being repealed, 1307, there was a fine for inducement by the prosecutor and the police. And I'm asking, where is the fine in this bill? Should those, if there is improper inducement, should there not be a penalty for those? Especially when the court is ruling on a situation and has to make a deliberation that the plea bargain in front of, or that's before the court, is one that was not subject to inducement. And if it was, then those who are responsible should face the full brunt of the law. And given that plea bargaining is maybe an area that will be highly utilized in the court, it should carry a hefty penalty. Because if you want to use it to increase the flow of cases through the court system, and their members or participants who opt for it, misuse of it should carry a hefty penalty. And in my mind, it's absent from the legislation. So I'm asking, can that be looked at and included in the bill before it's passed? And just to make a few comments, Madam President, with respect to the forms that are before us. Clause 3, Form 3 and Form 7 of the bill, or that forms part of the schedule at the end of the bill, speaks of the plea agreement, whether Form 3, a person is represented by an attorney, and Form 7, where the person is represented by himself. I am saying key pieces of information that I would have liked to see is not here. And this would include, 1, the name and jurisdiction of the court in which the matter is held or is currently before, the case file number or reference number for which the plea agreement is being made. I would like to see details of the prosecutor, because we would like to know who initiated this deal. I would like to see details of the attorney who's representing the accused, or or details of the accused if he is representing himself. However, given that it's an agreement, and the accused may be viewing this and not be aware of the law or his rights, I would like to see that the plea agreement is specific to the offenses listed and has no bearing on other offenses. A specific note on the bill indicating that the agreement does not bind the court to accept it. The accused has to know that whether or not, when the plea agreement is being engaged, that the court has the ultimate say, and that there are grounds for withdrawal, the consequences of breaching the agreement, and the right to appeal. This is like an agreement which informs the accused of his rights, and it cannot be taken in the context of an agreement only. It has to have the clauses and all matters that pertain to the accused that he's entitled to, because it's something that he's going to be bound by. And just a note that I believe on Form 4, I think with respect to Form 4, the accused or the defendant's signature needs to be attached to the form. And my last point, as I get ready to close, which is with respect to the victim impact statement with respect to the business, Form 2. With respect to Form 2, I think the name of the business needs to be included. The registered address of the business needs to be included. The address or location where the offense was committed need to be included, because there can be companies with several branches. And I also believe that with respect to the victim impact statement, it speaks of someone who can be authorized to create this. So I believe that details of the authorized person also need to be included. The letter of authorization should be included into this, as well as the name and address of the owners or directors of the company need to be included in the victim impact statement. And with respect to where they would have to submit their claim, supporting documents should also be attached. So, Madam President, as I conclude at this time, just to wrap up and reflect on my brief presentation here, I spoke this evening of what I would like to see, and one would most certainly be a better definition of the victim impact statement in the bill. The second one would be to give consideration to whether bad character should or should not be removed in a plea bargaining, and it shall have no bearing on any other offense, because it cannot be that the removal of bad character has a bearing on a subsequent offense or charge. That a specific clause that gives the accused the right to initiate plea discussions. With respect to victim impact statements, at what point in time does age 14 become an issue, whether it is at time of the offense or at time of the statement? I also ask that the content of the victim impact statement should not be able to be altered by the prosecutor, especially given the fact that there is direction for the court in 24.4 and 24.6. With respect to clause 25.5, I do ask that if the accused has the opportunity to cross-examine the victim, his attorney, if he chooses to be represented by one, should have the equal right. I would like to see that consideration be given to the court, for the court to specifically state that it has considered all the information in front of it in accepting the plea bargaining, and that there was no inducement, there was a factual basis, and there is acceptance of the plea, or acceptance of the plea would not be contrary to the interests of justice. Coming to the end, Madam President, I would like to see the last three recommendations, where I'm uncomfortable with the plea bargaining being made available for all offenses, and I believe that there should be a limit or classification of offenses for which the plea bargaining should be, those offenses for which plea bargaining should be illegible. Those accused should be. There should be a penalty for inducement, whether by fine and terms of imprisonment. And I've made several recommendations with respect to what I would like to see with the forms attached to the bill. So with those few words, Madam President, I would like to say that I understand the intent of the bill. I think it's good. I would love to support the bill. But there are some issues that were raised on the floor here that I have concerns with. And I too have had some issues with respect to some clauses of the bill, which I would have mentioned here. Whether or not it can all be worked out during the committee stage, I have my questions, but I remain open to its occurrences in this House. Madam President, I thank you.
Senator Coppin.
Thank you, Madam President, for the opportunity to contribute to this debate. This debate deals with an act to establish a system of plea discussions and plea agreements, and for matters incidental thereto. And, Madam President, I would like to start off by commending this honorable House, persons on both sides, for the camaraderie and progressive tone that this debate has taken on since its inception. And I think having Senator Chote commence the batting, as we like to say, on the last occasion, was able to set the stage for the tone which we have seen develop. And I perhaps would recommend that she open the batting and we take that responsibility away from Senator Mark, who often opens the debate up in such a way. But, Madam President, I would like to also say that the word debate is in fact a misnomer, because I think on both sides of the House, and we saw it in the other place, there is a resounding consensus that this is a good piece of legislation, Madam President. And Senator Ramdeen would have, in his contribution, commenced by also agreeing that this is a good piece of legislation, and he would have, in a very progressive manner, brought to this House a list of, I think, 25 recommendations that will engage this House when we do, in fact, go into committee. Unfortunately, Madam President, Senator Sturge came to this House today.
Can't help himself.
Can't help himself. And he proceeded to ramage, Madam President. Yes, ramage. But, Madam President, I am a jazz trumpeter. And one of the first things in ramaging is that one must be on the same, must be in the same key with your fellow band members. So, lo and behold, he came to this honorable House today and he somehow found all sorts, all manner of criticisms. But I would like to deal with those criticisms as I continue in my presentation. But, Madam President, this bill repeals and replaces the old Act with its 17 previous clauses with, I think, 27 clauses and 11 schedules. So the previous Act would have had 3 schedules, so it's an upgrade, and it builds in the same way that the Motor Vehicle Road Traffic Act built on the previous piece of legislation. It builds on a previous legislation that has been on our books since 1999. And, Madam President, Senator Sobers would have echoed a certain sentiment that this government, that this piece of legislation alone would not be sufficient to achieve some of the aims. And I will come to the aims a bit later. Some of the aims of this legislation. But if he understands this government's approach to crime and criminality, he would realize that in this session, I think over 90% of the bills that has come to this House are meant to deal with crime and criminality in Trinidad and Tobago. So it is not that we have come to this House only with this piece of legislation and think it's a panacea to solve the problems of this country. But, Madam President, I want to remind this honorable House of some of the legislation that the Honorable Attorney General has brought to this House. to deal with crime and criminality. And he has brought the Indictable Offences Pretrial Procedure Bill, Motor Vehicle Road and Traffic Amendment Bill, the Miscellaneous Provision Trial by Judge Alone, Cybercrime Bill 2017, Madam President. Bail, Access to Bail Amendment Bill, SSA Bill, Madam President. And Madam President, it's not only at the legislative side that this government seeks to deal frontally with the problem of crime and criminality, but we have, and it has been said, because Senator Sturge raised in this House a motion asking for the government to do all in its power to deal with the rising crime and criminality, Madam President. And we have done it. We are in the process on the legislative arm and on the executive arm, as in the other place the Minister of National Security would have indicated. We are currently providing manpower orders for those national security agencies. We are currently increasing the funding for national security, Madam President, and in the variation of appropriation bill, we would have seen that the Ministry of National Security was one of those agencies that benefited from an increase in allocation. And as it relates to DNA, because in this debate it was raised that without increasing the level or the rate of conviction and detection, then the whistleblowing legislation would be seriously hampered. And Madam President, we have for the first time in this country a DNA custodian that is going to be appointed. Has been appointed. And Madam President, that is going to lead.
DNA custodians is not in the bill.
You please.
And Madam President, Senator Sturge, he must appreciate that this government is a government that is truly working for the people of Trinidad. And they don't like to hear it, Madam President. They expect that they repeat the same thing over and over and expect that people would just take them at their word. But Madam President, we have a duty and a responsibility to educate this population on the actual workings and performance of this government. Now, Madam President, I wanted to deal with that. Now, Madam President, I want to deal with the mischief of this bill. And on the last occasion, it was read into the Hansard that this bill, the previous 1999 bill, was brought to the Honorable House by Ramesh, the former Attorney General, Ramesh Lawrence Maharaj. And in that presentation, in that debate, he would have cited two key objectives for bringing this bill to this House. And those were reducing, and I quote, to assist in reducing costs and time spent in trial, to create a situation whereby an accused be more willing to divulge information which would assist in the investigation and prosecution of the criminal elements, and to reduce the cost and time spent in trials. So those were two of the key objectives, one to deal with the criminal justice system, and the other one really to deal with the rate of detection and conviction, so allowing those persons with the relevant information to feel comfortable to bring such information to the fore. And Madam President, the mischief of that legislation is in fact the mischief of today. We have added, however, a further objective, in my estimation, which is to deal with the number of persons and the length of time persons are spent in remand yard. So these are the three major objectives or mischiefs that this particular bill, in my estimation, seeks to frontally address. Now, Madam President, on the last occasion, the Honorable Attorney General have given a number of statistics as it deals with the rate of disposition and matters filed. And he would have told us that the rate of disposition for criminal indictment is 0.045, which means that every year, or almost half the cases that are filed are put back into the system for the following year, which leads to a cascading backlog of cases in the criminal justice system. And Madam President, in the Joint Select Committee on Finance and Legal, we were able to get a number of statistics, as well as the Ministry of the Joint Select Committee on National Security. And some statistics that stuck out to me was in the average, for the last 6 years, the total murders filed, 219, but only 98 matters disposed. And of those, 46 capital murders filed, and only 15 of those were disposed. So, Madam President, we can see, as it deals with serious criminal conduct in this country, the case flow management system simply is not adequate. And Madam President, as we deal with remand yard, Madam President, is time?
Yes, time.
Honourable Senators, at this stage we will suspend and we will return at 10 minutes past 6. And Senator Coppin, you've used up 11 minutes of your speaking time. So we are suspended until 10 past 6.